Hello students. Uh, as you know that we were dealing about this course gender-based violence, and today I'm going to speak about this topic, women in institution. Let me introduce to myself. I'm Dr. Smita M. Patil, a faculty with School of Gender and Development Studies. The Indian Constitution mandates equality as a key principle of social existence, and yet many marginalized groups and community have to face discrimination and subordination. Women are one of the such group, and they have to negotiate with masculinist institution structure and processes in their day-to-day existence. We are going to focus upon women who fall into the category of so-called criminals as defined by the law, and understand the protective laws and the policy that are in place to safeguard their interest and also their experiences of violence and oppression despite these empowering provisions. How has the state tried to accommodate the concern of these women who are in the conflict with law? What happens when the protectors turn oppressor? How far is the law able to address the need of this woman? How can the state be made more responsive and representative? These are some of the questions that we will study in this lecture. Prisons have been a part of civilized society, as these are seen as correctional facilities that help in penalizing, reforming and rehabilitating those who have committed a crime and are serving sentence according to the law of the land. In India, the foundation of the modern prison system was laid down during the colonial period. The modern prison in India originated following the report of the Macaulay Committee or the Prison Discipline Committee, which was sort of established in 1836 and 1838 in between. Central prisoners were constructed from 1846, and the contemporary prison system has evolved from those days and grown to an unmanageable size. These jails accommodated, almost 478,600 prisoners as on 31st December 2019. The breakup of these figures include 458,687 male prisoners, 19913 female prisoners. These are the 31 women jails set up in only 15 states and union territories with a total capacity of 6,511 in India. The actual strength of the women jail officer staff as given in this data was 7,794, including 254 medical staff. Women prisoners thus form a very insignificant minority within the category of the jail inmates in India. Yet the number is large enough to require proper arrangements by the relevant state authorities. Women prisoners in India jails have to face problems like overcrowded jails, and severe lack of the female staff in the prison, including doctors, nurse, consular, fewer and unhygienic toilets and bathroom, inadequate provision of the water, scarcity of the menstrual hygiene products, inadequate nutrition, especially for the pregnant or the lacting women and their dependent children, outdated vocational training which is necessary for the proper rehabilitation, limited access to the legal aid, and threat of the physical and sexual violence at the hands of the other prisoners as well as the authority. Absence of effective complaint redressal mechanism are some of the key problems. There have been many incidences of the custodial violence against women accused or prisoners in India despite the guarantee of certain rights and protection available to them. Constitutional and statutory body provisions related to the women accused and the prisoners are there. So let us try to understand this debate also on this. What are the constitutional and statutory provisions are there? So some of the constitutional and statutory provisions that guarantee certain basic rights for women in prison. As we know that the preamble of the Constitution in India outlined the basic features of the Constitution by promising social, economic, political justice for all citizens along with the equality of the status of opportunity. Article 14 under the fundamental rights guaranteed by the Constitution of India in Part 3 guarantees equality before the law or the equal protection of the law to the citizen. Similarly, Article 21 lays down protection of the life and personal liberty as a fundamental right. These rights are equally available to prisoners with certain restriction in proportion with the criminal charges against them. The prison system in India is governed by the Prisoners Act 1894 and the jail manual of the respective status as a prison administration is subject to the state list under the Constitution of the India. The transfer of the Prisoners Act 1950 and the repetition of the Prisoners Act 2003 are some of the other relevant acts. These are specific provisions in the Indian Penal Code (IPC) that also provide certain safeguards to prevent violence against women in the institution like prisons. Section 376 of the IPC specifies punishment for the rape by the police officer within the police station or in any premises of the police station or in the custody of the police officer, members of the armed forces or any public servant. Section 376 Provision 2 provides for minimum 10 years rigorous imprisonment in case any member of the staff of the jail, remand home, other place of the custody, established women or children's institution, which means an institution whether called an orphanage or home for neglected women or children or the widow's home or an institution called by any other name or any such place that is entrusted the responsibility of women and children. Similarly, Section 46 of the Criminal Procedure Act Code CRPC provides for certain precautions like male police officers are not allowed to touch the woman while making an arrest. For the under ordinary circumstances, no woman is arrested after the sunset and before sunrise. The exceptional circumstances which such arrest is to made during the night require special efforts like the woman police officer is to prepare a written report and obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction the offences is committed or the arrest is to made. Section 51 provides that the female accused shall be searched only by the another female with strict regard to the decency. Section 53(2) mandates that the medical examination of the woman accused shall be made only by or under the supervision of a female registered medical practitioner. In the general provision relating to the searches in the CRPC under Section 103, in the case of a woman being suspect, search shall be made by the another woman with the strict regard to decency. Section 160 of the CRPC, which deals with the police officers' power to require attendance of the willingness while investigating a matter crime, provides that in the case of the woman, such investigation shall happen only at the place of her residence. Section 167(1) of the CRPC provides that when the procedure of the investigation cannot be completed in 24 hours in case of woman under 18 years of the age, the detention shall be authorized to be in the custody of the remand home or recognized social institution. Section 416 provides that if a woman sentenced to the death is found to be pregnant, the High Court shall commute the sentence to the imprisonment for the woman. Section 437 provides for the relaxed bail requirements in the case of women arrested or detained in case of non-bailable offence. Many of these provisions were put in the place following the Law Commission's 135th report on women in custody. There are international, instruments and the guidelines regarding this. Other than the aforementioned constitutional and statutory provision, there are numerous international instructions that lay down some basic human rights for the prisoners. While these international provisions are not binding upon the respective national governments, Article 51C of our Constitution directs the state to foster respect for the international law, tragedy obligation in the dealing of the organized people with one another. The court have often emphasized upon the need to respect those provisions while formulating national laws and policies. So we will take such relevant documents. We will take up to such of the relevant documents, like for instance, the United Nations Standard Minimum Rules for the Treatment of the Prisoners, which was published in 1955, were revived and renamed the Nelson Mandela Rules in 2015. So the rule one says that traces upon trailing all prisoners with the respect due to their inherent dignity and value as human beings, and any type of torture and other crucial, inhuman, degrading treatment or punishment, even in the face of gravest provision, is prohibited. These rules prohibit corporal punishment, punishment by placing in a dark cell, and all crucial, inhuman, and degrading punishment for disciplinary offences. Rule 81 provides for placing the woman's wing in the correctional institution under the authority of the responsible woman officer, who shall have the custody of the keys of all that part of the institution, and also provides the entry of any male member of the staff into woman's wing unless accompanied by the woman officer. It is also specifics that women prisoners shall be attended and supervised only by the woman officer, but makes provision for the male members of the staff on duty, particularly doctors and teachers, to continue with their professional duties in institution or part of the institution set aside for women. There is a more specific set of the rules for women's prisoner, the United Nations rule for the treatment of women prisoner, and the non-custodial measures for the women offenders, also called the Bangkok Rules. These states upon the need to take into account the differential needs of the women prisoners. Rule 5 specifies the provision of the facilities that take care of the women's specific hygiene needs, including the free sanitary towels and regular supply of the water for the personal care of the children and women, and especially for those who are pregnant, breastfeeding, or the menstrual. So Rule 31 mandates government to clear policies and regulation on the conduct of the prison staff aimed at providing the maximum protection for women prisoners. For any gender-based physical or verbal violence, abuse, and sexual harassment shall be developed and implemented. Other interventions by the state and its allied agencies are also there. The union government has in the past appointed committees for the prison reforms, and two such prominent committees have been there: the Mullah Committee on Jail Reforms in 1980-84, and the Justice Krishna Iyer Committee in 1987, especially to address the situation of the women prisoners in India. It has recommended induction of more women in the police force in the view of their special role in tackling women and children offenders. The Ministry of the Home Affairs regularly issues advisories regarding persons administration, including on the issues like overcrowding, educational programs for inmates, sharing best practices, extension of the medical facilities, including to inmates with the mental health related issues, to terminally ill inmates, grant of parole, and facilities to the children of the women prisoners, among others, and more recently regarding the COVID-19 related precautions in the prison. Some of these documents are available on the website of Ministry of Home Affairs, and you can sort of log in to those ministries and see those manuals. The Model Prison Manual of 2016 also is there, is a standard set of the guidelines approved by the Ministry of Home Affairs and circulated to all states and union territories. There have been parliamentary committees that have investigated the condition of women in prison and submitted reports and recommendations, like the Committee on the Empowerment of the Woman, 13th Lok Sabha, for instance, 2001 to also known as Margaret Alva Committee, after the chairperson of the committee, which report which was there. So this was given, and then you can see that the 16 Lok Sabha 2017 and 18 documents also by sort of checking those website if you want to learn something more about it. There have been various judgments pronounced by the Supreme Court of India regarding the rights of women prisoner, and mention can be made few here, that Hussain Nara Khatun versus ORS, Home Secretary State of Bihar, versus AIR 1979 SC 1360, and then Upendra Bakshi's judgment is there against state of. So you can see and read while engaging with that. So a number of judgments are there which is dealing with that. So another effective intervention by the Supreme Court of India have been initiated on the basis of the letter written in June 2013 by Justice R.C. Lohidi, third Chief Judge of Indian Supreme Court, to the Chief Justice on overcrowding, unnatural deaths, inadequacy of the staff, and inadequate training of the staff in the Indian prison system. So letter was taken up as a writ petition to remedy the inhuman condition prevailing in 1382 prisoners in India. Consequently, from 2016 to December 2018, several judgments are there which is dealing with the inhuman conditions in 1382 prisons have been delivered in relation to these petitions. So, prisons in India, there are the committees to enabling provisions related to the women prisoners mentioned in the previous, talk which I dealt with. But and the well-intentioned efforts of the various agencies of the state have been not able to ensure a dignified life of those women in the custody. The Alva committee mentioned some problem with regard to the women prisoners, like absence of the standardized and uniform treatment throughout the country, as prisoners management is a state subject, even though the center can issue the guidelines and decides larger framework of the prisons management and the reform. The committee also raised issue like difficulty in conducting surprise visit to those jails to assess the prevailing condition. Female jails enclosures being managed by male staff instead of the woman personnel. The committee also raises issues like difficulty in conducting surprise visit to those jails to assess the prevailing condition. Female jails enclosure being managed by the male staff instead of the woman personnel. Overcrowding in some jail, outdated and nominal facilities for rehabilitation, lack of the crutch, educational facilities for children staying in the jails with their mothers, substandard condition relating to the food, lodging, clothing, recreation were other concerns. The district jail Lucknow found a special mention in the report. As the committee found that the women convicts were not informed about the wages earned by them, and no account were mentioned in this regard. Apart from the everyday and the routine violence that women in detention have to face, sexual violence and physical abuse is also rampant. So you might, knowing and read about the Mathura rape case, an incident of the custodial rape, where in Mathura a young tribal girl was allegedly raped by the two policemen in the compartment of, police station in the Gadchiroli district of Maharashtra, which was way back in 1972. So after the Supreme Court acquitted the accused, there was public outcry and the protests, which eventually led to the amendments in the Indian rape law in 1983. There was not an isolated incident, and the People's Union for Democratic Rights, a Delhi-based civil liberty organization, published a report in 1994 on custodial rape in Delhi only, and the number of custodial rape were given as a 21 between the period 1988 to 1994. This is what the PUDR report says. So this report also pointed out how, in the context of the rape or sexual assault, the woman is reduced to a name or another number, as it emphasizes on the outcome of the related judgment, and the media also sensationalizes. Media also informs the case, the debates on the need to do the reform, the legal system. The experiences of these women, their physical and social vulnerability to the sexual assault, the consequence, the fear of those consequences does hardly get addressed in these debates. Even the Alva committee admitted in 2001 and 2 report that and I'm quoting from the report, there were also some cases of exploitation of young women prisoners by the jail staff for the immoral purposes, unquote. The 2018 Parliamentary Committee on the Empowerment of the Woman, in its report on the women in detention, mentioned that it was informed by the Minister of the Home Affairs that in the state of the Uttar Pradesh, there were 189 cases of the custodial rape in 2014 and 91 in 2015. The print and electronic media also constantly reports these instances of the violence and abuse, but the ground realities of the hardly changes. The government of India has still not devised modalities of the consistent document of the torture-related complaints. The National Crime Record Bureau NCRB does not document cases of the custodial torture through physical assault might figure in some cases of the custodial death. The National Human Rights Commission also prepares occasional reports about the police exercise, but no sustained and regular documentation is done. Kaur points out that torture, excessive force is often used to target marginalized community and control people participating in the movements or propagating ideologies which the state pursues as threatening. Ginny Loknita, who has worked on this in 2014, described it as a public secret that the state continues to deny, and yet there is a silent acceptance as it continues to haunt us through frequent incidents that get reported in public domain. So we have to, sort of constantly engage with the state and the issues which are coming up in the prison. Now, the feminists have done a major intervention to it. We also familiarize that familiarize ourselves with the existing framework of the laws, guideline, and the policy enforced to address the vulnerabilities of the woman in custody. But we also realize the futility of this provision, as even reports by the government agency indicates the existing prison system for treating the female inmates in inhuman ways, but there is no accountability at any level. Convictions are few as supporting evidence is difficult to produce. The repressive power of the state machinery gets active in defense of the accused official and the cover-up in the arrangements through various modes. Criminal women already have low credibility and unlimited means. Their socioeconomic background add to their vulnerability. Acquittals and installments are common in the most cause of the custodial violence. So, inquiry officer faces pressure to prepare a report favoring the accused, and there is an institutionalized reluctance also as a police hesitating to taking action against the colleagues. Similar things happen in the case of the Manjula Shetty case, as Maharashtra DIG prison, posted in WhatsApp prison, the Swati Sathe posted WhatsApp messages in the group of the colleagues from prisons department seeking support for 6 jail staffers arrested in the case. Sathe called the accused as the sisters. She was subsequently relieved from conducting the departmental inquiry. The existential constitutional provision, laws, policies, and guidelines that are presently in the place adequate to give these women relatively violence-free and dignified life in the prison or other protective institution. These are not just benevolence gestures of the welfare state, but also as a result of the years of the struggle by the autonomous women's group as well as the civil liberty group active throughout the country. The outcome has been success, as Rajeshwari Sundararajan points out, but only in terms of listening of these provisions in the official document. Now, Sundararajan argues that the inclusion of the feminist concern into official mainstream discourse enhances the fear of the co-option as well as competition as the state continues to adopt the paternalistic relationship with women in the name of protection. Most of the provisions related to the woman in prison still construct these women in conflict with law as a sexualized reproductive subject, and hence the emphasis of the reform or empowering provisions in the safeguarding maternal health and ensuring the health of the children of the woman in prison. These constructive and family-oriented views thus fail to take up into account the differential needs of the different categories of women in the prison. There was no mention of the woman prisoner with the disability and the need to accommodate their specific requirements in any of the existing provision except for the mention of the mental health and the need for the psychiatric care. Sign language and foreign language interpreters are not only on the list of the experts needed for the dignified existence in the prison. There was no mention of the caste or the tribal identity based operation, as a women prisoners are treated as a homogeneous group with identical requirements. The ideology of the protection also renders these women incapable of being trusted with any active agency, as they are not involved in the management of these institutions that are solely governed by the state across. The power of discretion given to the jail staff in the terms of using force is a gray area that allows legal violence against the inmates. Sundararajan also attributes the inhuman condition in the institution for the woman to cruel regulation upholding the bureaucratic norms of the discipline and motivated by reformist intention, where supervision, confinements and deprivations are the key concern as well as strategies of the management. So we need to, in fact, we do not need more laws and policy to address the inhuman condition existing in the jails, but need to strategically work on the gaps in the conceptualizing the idea of the institutionalization in the context of women coming from the different socioeconomic and political background and their specific needs. There is need to think about alternatives to the prison as well. The penal as well as the non-penal institutions should be democratized, and greater participation by the inmates and the member of the civil society should be inbuilt into the system. Systemic accountability should be enforced stringently, and zero tolerance for human rights violations should be the key responsibility of the various stakeholders, both state and non-state actor. So the whole argument which was there in this, the central or the core idea of this talk was to make you aware that the woman in the institution, particularly in the prison, what kind of laws are there, what kind of safeguards the constitution has provided, and over a period of time that various commissions sets by the government of India, even in the current government actually, to deal with the women prisoners and what are their rights are. Thank you.